Thank you, Ramin. Thank you for your kind invitation to take part in this conference. Good morning, still good morning to everybody. I'll try to keep in my mind two important remarks. First, I need to assume that I cannot explain all issues I would like to explain because this is a huge field. The case law of the court on respect to human rights when countering terrorism. So it's impossible for me, even if I should, it's impossible for me in half an hour to go through all issues. So I will just mention a few, but I'm open to any questions later on. And second, that you need to have lunch. So I will try to keep attached to my time. Also, I will try to keep close to the issue included in the program. So not all human rights, even if some of them are very important, and the case law developed by the court is so crucial, as for the right to life or prohibition of torture, Articles 2 and 3 of the Convention, Article even 4 of the Convention. I will just constrain myself to talking about the two issues underlying the program. So detention and prosecution, concerning mainly Articles 5 and 6 of the Convention, and then the fight against radicalisation in narrow contact and relationship with the topic we've seen right now, concerning mainly main freedoms, Articles 10 and 8, also Article 8, right to privacy, but also liberties, Articles 10 and 11 of the Convention. I cannot go into many cases. I've put many, I do understand. So I know that my presentation is not very pedagogical. But I tried to put a number of examples. It was even impossible to give you a full list of cases because there are hundreds of cases produced by the court, taking into account that the European Court of Human Rights is the most important court dealing with terrorism issues, because we have just a couple of judgments by the International Court of Justice, just one indicted judgment produced by the International Criminal Court concerning the destruction of cultural property and directly connected with the terrorist group. A dozen of cases on this issue produced by the Inter-American Court of Human Rights. Some cases produced by the European Court of Justice, but focus on very specific matters. But the huge case law produced on terrorism and human rights has been produced by the European Court, and taken also into account that we are talking here of cases concerning not only the 28 members of the Union, where it is easy after a sort of harmonization and the setting up of very close and legally binding mechanisms for cooperation. It is not the case in the Council of Europe, where we have 47 member states, some crucial states in the fight against terrorism, such as the Russian Federation, Georgia, or Turkey mainly. So that's very important to keep that into our minds. A few general remarks. We are facing a new concept of terrorism, a global terrorism with new features, and in particular with new specific ways of performing terrorist offenses, which is very important. In fact, you were talking, you posed a question, some of you posed a question previously concerning the financing of terrorism. Well, now what is being much researched within an international organization are close links existing between transnational organized crime and terrorism, because terrorism is no longer anything similar to that idea that we could have in mind, romantic idea in a sense, even if not legitimate, of course, romantic idea of the fight of oppressed people for their freedom or for their homes or whatever, even if not legitimate, obviously, but nothing to do with that. We are talking about mercenaries, we are talking about money, we are talking about control of the territory, we are talking about power, we are talking about drug trafficking, smuggling of migrants, trafficking in persons, trafficking in organs even. So it's much wider. Ways of performing terrorist offenses has changed quite importantly, during the last few years. The European Court of Human Rights also is facing new challenges in the case law being produced these last years. Issues such as the role played by new technologies, which a lot of influence on, for instance, prosecution, the problem with the e-evidence for prosecutors, the problem of self-radicalization through the web, for instance, which has been included in the new protocol and also in the new directive replacing the framework decision, extraterritoriality or the extraterritorial application of the European Convention in many cases, and the problems that this has posed concerning some specific states, for instance, the United Kingdom, with those cases decided by the European Court on the behavior of members of the army in Iraq or Afghanistan, for instance. Also the foreign interest fighters phenomenon. It's very important to remark since the very beginning that the court, when deciding on a case on terrorism, is always very aware of the fact of being a subsidiary court, which is very important. The doctrine of subsidiarity, the margin of appreciation belonging to state parties to the convention, and the fact of considering the European Convention as a lively instrument, so an evolving legal instrument that has to be construed and implemented by the national states or party states to it in a lively way according to the circumstances in each case. There's always some mistakes, spelling mistakes that you cannot see when you deliver the presentation well. These are the main points concerning detention. Article 5, the right to liberty and security, because we need to talk about detention and prosecution. The main problems: arbitrary arrest, pre-trial detention, extraordinary renditions, suppression of habeas corpus, detention, right to life, or implications concerning torture or ill treatment, and detention with a view to deportation or extradition. The general principle enshrined in Article 5 is the prohibition of arbitrary detention. So the deprivation of liberty is forbidden by the Convention, with the only exception of legal grounds for such deprivation of liberty. And those possible grounds for deprivation of liberty are exhaustively enshrined in Article 5. So the court has once more said, once and again said, repeated that the only possible limitations to that liberty, to the right to liberty and security, are those included in that article, and that they had to be construed, interpreted in a very narrow, strict way. Detention has always to be justified, and we need to keep in our minds the difference between detention in police hands and pre-trial detention, right? Because in the middle there is a judge acting and putting in prison that person for pre-trial detention in order to be prosecuted later on. The detention has to be consistent with one of the grounds provided by Article 5. We will dismiss the two last points included in Article 5 because they are not interesting for the fight against terrorism. But imprisonment following conviction, that's a normal case. It is the same for regular criminal offenses than for terrorism. Detention for reasonable suspicion or to prevent the commission of a terrorist attack, or deportation for extradition. And these two are the most controversial ones. Reasonable suspicion, well, any terrorist offense has to be previously established, which means that has to be included in law, in enforced law, which is nothing different from respecting the legality principle also enshrined in Article 7 of the Convention. The purpose is to bring the detainee before a court. That's the only purpose of detention, to bring that person before a court and to do it in due diligence. The reasonable suspicion means that there are facts, events, informations, real facts, true informations, consistent elements to think of a reasonable commission or a threat of commission of a terrorist act. It is not necessary for the court that there are previous links of that person time ago, time before, with any terrorist movement or even previous condemnations for terrorist offenses. But in that very moment when the person is detained, you need to show that the state needs to prove that there is a reasonable suspicion that there are informations, facts being in the hands of the police, pointing to that probability or that possibility, not just mere suspicions or any kind of general ideas, which is forbidden in accordance with the case law of the court, is any general policy, preventative policies. So you cannot be detained on general preventative ideas or principles, but for factual individual behaviors of the detained person. For instance, there was a very known case, the case of Murray against the United Kingdom. I don't know if it's put inside the presentation. The Murray case, marriage being suspect of having developed activities for financing terrorism, but at the time of the detention, the police was unable to provide any individual precise, specific facts, events, information that could connect those people with those offenses or potential offenses. So the court condemned the United Kingdom, taking into account that there was no reasonable suspicion of those two people, the marriage, being involved in financing of terrorism. These reasonable suspicion is applicable not only when detention takes place in the territory of the state parties to the convention, but also when the detention takes place abroad. That was the case of O'Callaghan, the leader of the PKK, at the moment in prison at present, where the detention took place in Kenya. So the case that was brought before the court twice for different reasons gave the opportunity to the court to pronounce on this point. The requirements are exactly the same, even if the detention takes place outside the territory of the parties. It doesn't mean that the police or the authorities detaining the person in question need to provide all elements for that detention, because obviously the fact of putting that person in detention is in order to, one of the main aims is to continue to follow the research and the investigations, but the detention has to be on grounds of some account, some facts, not full reasons, but at least some reasons, and some objective elements evident for any objective observer, which means for the court that any person, any normal citizen could understand that with those elements there is a reasonable suspicion that that person could finally carry out a terrorist attack or is potentially involved in a terrorist attack. Conditions of detention in terrorist cases. Well, there is a exhaustive list included in Article 5 of the Convention, and as I said before, they need to be narrowly interpreted by the national authorities. There is no real, a very wide margin of appreciation on the side of national authorities. There is an obligation to comply with the minimum guarantees, because this is the main ground for a rule of law state. So the court so declared in the case of 8 and others against the United Kingdom, where 11 people were detained. Some of them were put in prison, some of them were surveyed meanwhile in hospital. Some had evidences of having suffered from torture. Some were detained at home under administrative detention, a new concept that appeared after the events of September 11, very much used by some state parties to the convention. So reasons have to be given for the detention, have to be provided in detail and promptly. This is not a key issue. For instance, there was a very important case, Tomasi, against France, where that person, suspect of having collaborated with the terrorist, Corsican terrorist group, was detained for a number of days before being brought before the judge. And later on, that's why I mentioned before, we need to keep in mind the difference between the period in detention at the police headquarters and the pre-trial detention once the judge has already seen the person detained. Here, Tomasi was detained for a number of days at the police headquarters, and then later on in the pre-trial period, he waited for 5 years and 7 months. So that wasn't reasonable at all, as the court said, but it was even worse in the case of Aksoy against Turkey, a girl who was detained under the suspicion of being involved in terrorist activities, but she was just a sister of somebody, a young guy suspect of belonging to the PKK. And it seems to be the only way of reaching the brother. The girl was not really the interest of the authorities, Turkish authorities, but her brother. And she was tortured and kept in the police headquarters for more than 16 days without being brought before a judge. So the court considered that to be unacceptable. In fact, the court fixed a maximum time in the case of Brogan and others against the United Kingdom of 4 days and 4 hours, 6 hours of being detained in police hands before being brought before a judge, being the maximum time for being detained by the police. This has not been fixed in the case of the pre-trial detention period. There is no maximum time, but obviously the case of Tomasi, 5 years and 7 months, or even more, the case of another case against Turkey, Calais against Turkey, 12 years for the proceedings. Seemed to be too much for a due process in a reasonable time. The habeas corpus, and additionally, the detention has to be duly authorized by the judiciary. Obviously, even if there's no need of giving full account of the reasons, just the most important ones, as I mentioned before. If there is a possibility of renewal, it has to be established also, and the presumption of innocence has to be respected at all times. There is no obligation on the side of the detainee to cooperate with the police during the detention period, and has the right to remain silent even if later on, for other circumstances, this fact can be negative for his or her situation, but in principle, there's no obligation to cooperate. There is no excuse for states, for instance, in saying that this was a long detention period in police hands because there were a high number of persons involved in that attack or in that potential attack or a terrorist action, or because of the complexity of the operation, the terrorist operation. That's not an excuse for the court or in favor of state before the court, the European Court of Human Rights. The habeas corpus is the right to challenge lawfulness of the detention before a court. Well, this has been perfectly declared not only by the European Court of Human Rights, but also by the Inter-American Court of Human Rights and the Council of Human Rights of the United Nations. And the reason is why it's an obligation that gives the opportunity to protect the detained person, the terrorist suspect, in particular when we're dealing with vulnerable groups. And I would like to make a mention here, because sometimes persons having been involved in this kind of events, terrorist attacks, terrorist threats, and so forth, and we are witnessing that nowadays with these new forms of terrorism and precisely with the self-radicalization phenomenon and the foreign service fighters phenomenon, many of the recreated people, and I should say that with the due respect, have some kind of mentally weak minds or weak personalities, so they're easier to get recreated by those network through these nets, these kind of associations or criminal groups, terrorist organizations, through the web, through the network, through the internet. So these people needs to be taken into account when they are vulnerable. The fact of being illiterate when being interrogated by police or before the judge, the fact of being illiterate and not having the possibility of using a translator, for instance, and you do not understand exactly what you are being accused of, and that has been the case a few times and in different cases before the European Court. The obligation to protect is enshrined in the habeas corpus right to protect the detainee. The detaining authority must have also the power to review the order given to keep that person in prison or the condemnation, and also the power to release the person in detention. Here plays also an important role the right to legal representation, and that's very important nowadays also, because after the events of September 11th, the mantra repeated by states is the national security imperative. So on behalf of the national security imperative, you cannot disclose information, you cannot allow some guarantees to deploy, to develop full effects. So for instance, in the case of A and others that I mentioned before against the United Kingdom, the treatment was quite similar to the one for detainees in Guantanamo Bay prison being judged by military commissions, because there, in that case, those people had a legal representative, a lawyer, defending their rights, but the lawyer didn't have access to the full file and all information concerning their case because of the national security imperative. So that information was very sensitive for the state and couldn't be disclosed to the lawyer. And the European Court reached to an intermediate solution. It is true that sometimes disclosing that information could frustrate a very important counter-terrorist operation, or could end in the hands of other terrorist organizations. It's very important to protect at some point this kind of information, sensitive information, but there's some intermediate possibility. For instance, appointing a special lawyer in accordance with the applicants and the defendant state, and also the possibility of disclosing at least partially the information having against the detainees or persons to be judged for those offenses. In the case of O'Callaghan, for instance, the possibilities he had to keep in contact with his lawyer He was put in prison in an island out of Turkish territory, obviously belonging to Turkey, under Turkish jurisdiction, but out of the continent, in an island where a prison was abandoned. He was the only prisoner there. He was in incommunicado system, even if there was nobody else there. And he had only the possibility to meet his lawyer twice per week for 1 hour, and with the presence of prison officers, so not secret communication, the legal privilege, secret communication between the lawyer and the detainee. So the court considered that the right to habeas corpus was not respected in this case, neither as it was in the case of A and others. When it comes to the problem of asylum, refoulement, expulsion, deportation, or extradition, well, we have also a number of important, crucial cases. Here, the mantra also repeated by the states was that the states need to strike a balance between the right to liberty and security and the protection of national interests and national security and citizens, according to Articles 1, 2, and 3 of the Convention. And the court said, yes, you're right, you have that obligation to protect your citizenship, your own nationals, but you also are obliged to comply with the rights enshrined in Articles 5 and 6. So one of the issues dealt with by Article 5 when dealing with detention is the possibility of detaining somebody with a view to being expulsed or extradited to a third state. Could it be a party to the convention or a state outside the convention system? In the case of asylum and refoulement, well, it is even stricter on the side of the court, because all member states of the convention, all state parties to the convention are also parties to the Refugee Statute, the Geneva Convention on the refugee, on the status of the refugees. And there, it is true that if the person has committed a serious offense, it could be refoulement, it could be exposed and returned to his or her home country. But it is also true that in the Convention Against Torture, the CAT Convention of the United Nations and the European Convention also, there is a stricter concept of refoulement and refugee protections and asylum seekers protection. So the court decided to come attached to this stricter definition and this wider protection. And even the court has expressly stated in different cases, in different judgments, that the court is perfectly aware that the threshold being fixed in its case law is higher than the threshold fixed by the Refugee Convention. And it has perfectly accepted criticism on the side of states concerning this point. Why? Because the court maintained, for instance, in the Sadi case against Italy, which was a very difficult case to decide, because Sadi was a Tunisian guy living under the refugee status in Italy for years with his family, but he was the brother of somebody, a guy who had immolated himself in a terrorist offense, in a terrorist attack, and he was under suspicion of being sympathizer of the same terrorist movement. And there were many facts pointing in that direction, but the problem was that if returned to Tunisia, where all reports collected from different NGOs and some other, even the European Commissioner for Human Rights, all the authorities underlined that torture still existed there, and the person could came across a flagrant denial of justice, being subject to undue process there with no real guarantees. Finally, Italy was condemned because of the attempt to expose, to refold that person. And there was a sort of rebellion on the side of the state saying, we are not obliged to keep those, let's say, bad people, bad guys in our territories compulsorily, just because they cannot be returned to their places. So the second phase arrived, which was the possibility of seeking for diplomatic assurances from states in order to legally refoul those peoples to their home countries. So asylum has been a very critical issue as far as guarantees and respect for human rights is concerned in the case law of the European Court, and still is. Extradition also, and not only extradition has to, in case of extradition, detention with a view to extradition, all elements concerning current detention has to be observed. So there needs to be an order of extradition which has been issued. The detention has to be for a reasonable period. Some rights have to be respected meanwhile, but also the order has to be individually reasoned, so concerning behaviors, information, facts related solely and uniquely to that person, not in general terms, and the possibility also to be challenged by the person subject to that extradition order. But also the problem is the conditions in which that extradition takes place. And here is very important cases against the Russian Federation, Ukraine, or Georgia also, because sometimes those people were put in prison all together. There's a case of 16 people being in the same prison cell all together, without ignoring completely that they were going to be extradited to a country where all were going to be extradited to a country, Uzbekistan, where all reports said that torture still existed and that they wouldn't be subject to a fair trial. And they were put all together in prison and were informed at the very last moment, 1 hour before being delivered and then being rendered for extradition. They were informed of that fact. So they reacted, the prison warders reacted in a very aggressive manner. The prison cell was burned and 2 people died. So also the conditions in which extradition takes place is very important and has to cover all quarantines and respect rights enshrined in the Convention. The guarantees offered by the countries when accepting extradition has been deeply analyzed by the court in the case of Abu Qatada, Othman, the case of Abu Qatada against the United Kingdom, because those guarantees, it's easy to give guarantees or diplomatic assurances saying we're going to treat this person properly in an appropriate manner, and he or she is going to have a fair trial. But you need to have some control of the subsequent process in that country. So in that case, the court reached a real commitment on the side of the country. The person was going to be surrendered to Jordan, that person wouldn't be subject to torture or mistreatment, and a commission was created in order to survey the guarantees established by the court. Article 6, judging terrorist suspect. I will go faster. It includes or involves the right to a hearing before a judge within a reasonable time by a tribunal. The length of the proceedings, we've talked about that already, by an independent and impartial court. And here we have some problems, not in abstracto. The case law developed by the court has built to a particular system in order to check if the court is impartial and independent. So there needs to be, there needs to exist a double check as a subjective test and objective test. The court or the members of the court or judges have to be, from a subjective point of view, independent themselves and impartial themselves. But also the circumstances surrounding those judges, the procedure, the courts as a collegiate organ has also to comply with those conditions, impartiality and independence. And the problem came with the military members of the Turkish courts adjudicating on terrorist cases. So in those cases, the courts in Turkey always included a member of the army. The court said that the presence of a military judge per se didn't render the tribunal void or null. It means that it was accepted, it could be valid. It didn't imply there was no presumption of being impartial or not independent. But from a subjective point of view, or according to the subjective test, if the moment they undergo the same background, the same instruction, the same way of being selected for adjudicating cases in a court as their civilian counterparts did, there was no problem. So from that point of view, from a subjective point of view, there were no constraints of having a military judge in those courts. The problem came later. Well, they were there with the same background, with the same features, under the same premises than the other members of the court, but in fact they still belong to the army. So their progress within the army depended on military authorities, and military authorities receive orders directly from the Turkish government. So not because of the subjective test, but because of the objective test, the court decided that these kind of tribunals could reasonably create doubts and fear in the accused person of being subject to an unfair trial before a non-independent or non-impartial court. And finally, and this has disappeared, Turkey has no longer introduced a military judge in those courts, fortunately. The presumption of innocence has to be respected not only by the judge or the court adjudicating of the case, but also by any other authorities. For instance, it was a case of Hulki Günes against Turkey, where the chief national prosecutor made some declarations to the media with the presumption of culpability, the person being guilty of having committed a terrorist offense. It is true that it was not the judge adjudicating on the case in particular, but it was a very important authority in the country. So the European Court understood that these kind of statements ran counter the presumption of innocence. Also, the fact of creating an aggressive environment for the detainee person or for the person in pre-trial detention conducive to self-incrimination is not accepted by the court. I won't continue with Articles 5 and 6, but rather with the liberties and the fight against radicalisation, which is very important and keeps pace with the presentations we've seen before, because here the convention allows states to strike a balance between national interest and the rights of the person accused or detained, mainly accused. Well, here we find new threats, new challenge for the European Court, for the whole European system of protecting human rights. The surveillance, secret surveillance, which is very on fashion nowadays, in particular taking into account that that methodology or technical devices for conducting such a surveillance are more and more sophisticated ones. There have been a recent pronouncement on the side of the court, for instance, in the case of Saban Visi against Hungary, or in the case of Saharov against Russia, and some others against Turkey, where the court has considered that some guarantees, taking into account first that the fight against terrorism is becoming more and more complex nowadays, obviously, that's clear for the court, but also taking into account the advancement, the new technologies being in presence in these cases, and also the power that the state has to control those new technologies and the secret services and the use they do of these new technologies. The court has considered that some guarantees are essential if we want to understand that the fundamental rights are being guaranteed. The existence of previous judicial authorization, which was not the case in the Russian Federation. You don't need a previous judicial order issued in order to survey somebody. So previous judicial authorization, the knowledge about the duration of the surveillance, and also the possibility of renewal of that surveillance, and for how long it can be renewed, or which is the periodicity of that renewal, the communication to the affected person once the surveillance has been ended, about the possibility of challenging that surveillance before a court, offering him or her a domestic remedy concerning that surveillance. There was, for instance, a case in Turkey where one person considered by 2 years ago by the current Turkish government, considered as suspect of terrorism, was deprived of any access to the internet, not only to his own website, but internet in general. And the court considered that, taking into account all the tools, useful tools in many times from a professional point of view, most needed for people, for current citizens, being in the internet, being people being in need of using them, you cannot cut all access to internet to a person. You can cut the access on special grounds to particular websites, but not in general, because that would run counter the right to to freedom of information, or freedom of expression also. Personal integrity, Article 10 and Article 11 have to do with those liberties closer to potential radicalization. If you don't allow people to gather or to constitute a political party, if you do not allow people to communicate their ideas on the media, for instance, if you cut completely those possibilities, you can get those people, those groups, completely radicalized. It was the case in Turkey also, where one newspaper was not only closed but burned, and 2 people died as a consequence of those events, because they were considered to support the PKK movement, just because there was a column periodically talking about the history of the Kurd people. And examples like these are quite a few. The hate speech, well, the court has been very careful in establishing the difference between vehemence in the discourse and freedom of expression and hate speech. Vehemence of the discourse, well, there is an obligation in particular on the side of the governments to accept ideas that shock, disturb, or can be unpleasant, can be hard criticism towards the action of the government. this is part of the rule of law principle. But even though being this the case, there are a number of conditions that have to be observed. You need to introduce those limitations to freedom of expression in a law. They have to be foreseen by law. The law has to be a quality law, which means that there has to be an accessible law to everyone, publicized, that can, whose effects can be easily foreseen on the side of any person acting in that way, and that pursues a legitimate aim. On the other hand, if there is a special mention to some particular group, particular people in very hard terms such as brutalities, massacres, murder, gang, taking place precisely during a special period of insurgency, as it was the case, for instance, in Turkey, the court had no problem in recognizing there a hate speech situation. So, and that can take place either through the discourse, through a written discourse, or even through any other forms of expression such as poetry or even cartoons, like the case of Leroy against France demonstrated. There are a lot of things to say still. I knew I couldn't go through all of them, so I will be more than happy to answer any questions you might have. Thank you very much.